I don't know if she doesn't really mean take you out. She'll just
Take
get you out of the meeting.
Okay, we are on YouTube at this moment. So, Ms. Barron, it appears that the alleged father and the mother are appearing again in the same location. Do you have an objection to that?
No, I have no objection to that. I had a chance to speak with my client already. And because Mr. Harms has been brought in as a party being the alleged father, I think it's necessary that he participate.
I'm not objecting to his participation. I'm objecting to not following the Zoom rules that they're in the same location. So are you okay with them sharing the same site?
I'm fine with them sharing the same phone. I think they only have access to the one, Your Honor.
And Ms. Rush, do you have any objection?
No, ma'am. And Ms. Barron and I have been communicating via chat, but Mr. Harms obviously doesn't have an attorney. If Ms. Ladd and I could have just a breakout room with him, I'd like to get his email since he doesn't have an attorney, as well as discuss the orders with him.
Certainly. And parents, I don't know which one of y'all is working the phone. I'm going to send an invite. And so if you'll just check yes to the invite to the breakout room. If anyone other than Ms. Rush or Ms. Ladd or the parents receive an invite to a breakout room, please ignore. And I will note for the record, anyone that may record, download, or post any portion of this court hearing, that is strictly prohibited and you could be held in contempt.
Yes, ma'am. A couple of things. After I got to the Wichita Falls office, after court this morning in Young County, I filed Mr. Puller's declaration on behalf of the Chickasaw Nation. It was e-filed. Whether or not it's been accepted yet, I don't know.
I do have a copy of that. Mine is not file marked, but I printed it off as soon as I got back in, and it's probably been about 30 minutes since I've looked at e-file. So, Ms. Barron,
and I believe we do have an agreement is what I was going to say. I'm sorry.
Okay. Ms. Barron, do you have access to that declaration?
I'm on mute. No. Okay. I looked in my email to see if anything was e-filed just before logging on and nothing came up, but that doesn't mean it's not there somewhere.
Your Honor, I'm going to email it to her right now.
And okay. Ms. Ladd, do you need it emailed? Will you email it to Ms. Ladd as well? Do you have
yes, ma'am.
Were you able to get a email address for Mr. Harms?
Yes, ma'am. And I've asked Ms. Barron to, if she will not on YouTube, give us the her client's email.
I sent it to you.
The court will take judicial notice of the contents of its file. And Ms. Rush, if you will start with announcements, please.
Ursula Rush and Tim Scantlin for the department ready.
Jordan Barron, attorney for the mother. Alexis Morgan, she's present. We're ready.
Sarah Ladd, attorney for the child, and I'm ready.
Laura Lyerly Casa.
The court will note that the placement is present, as well as the representative from the Child Placing Agency, and Mr. Puller, who is with the Chickasaw Nation, is present as well. Mr. Trevor Harms, the alleged father, is present, and he is sharing a device with the mother, Alexis Morgan, and all parties have waived the requirement for them to be at separate locations or using a separate device. You may proceed, Ms. Rush.
Department calls for a very limited purpose. Miss Morgan, Alexis Morgan. Thank you. May it please the court. Ma'am, I'm going to ask you what may seem silly questions, but it's mainly for spelling and things, okay? Are you there?
Okay. Yes, I'm sorry. I know you nodded your head. This is all being recorded, so I'm going to need you to speak out.
Yes, ma'am.
Thank you. You may proceed.
And I'm actually reading, I'm sorry, I'm reading something, so I'm not necessarily looking at you, so I can't see you nod. Is your name Alexis? Okay. Were you born in 1993?
Yes, ma'am.
And are you the mother of Presley?
Yes, ma'am.
And was she born in April 2023
Yes, ma'am.
in Wichita County,
Yes, ma'am.
right?
Yes.
The only Native American tribal membership you have is with Chickasaw Nation, correct?
Yes, ma'am.
Do you believe you are eligible for membership in any other American Indian tribe?
No.
Okay. You understand that your attorney, Ms. Barron, has told me that you are in agreement with the department maintaining temporary managing conservatorship and you working services and us doing everything we are required to do pursuant to the Indian Child Welfare Act. Is that correct?
Yes, ma'am.
Okay. I'm also going to tell you that we are asking the court today to order you to do a hair follicle and a UA. Do you understand that?
Yes, ma'am.
This court has a policy that as long as you do the drug testing, your visitation rights are not suspended. If you don't do the drug testing, you lose the right to visit. Do you understand that?
Yes, ma'am.
Okay, so the whole idea is don't not test just because you think it's going to be positive. That's the worst thing you can do as far as visiting your child, okay?
Okay. Yes, ma'am.
Okay. Danelle Columbus, who is blacked out for whatever reason, is going to be your caseworker. Do you understand that?
Yes, ma'am.
Okay. And I won't go into who it is, but you have given us a relative in Wichita Falls and a godparent in New Braunfels, Texas as possible placement. Is that correct?
Yes, ma'am.
And I believe the relative in Wichita Falls, the home study has started. Do you understand that?
Yes, ma'am.
Okay. I'm going to ask you now, do either of those people have any CPS or criminal history?
No, ma'am.
You understand if they do, the chances of them being approved are going to be very slim, right?
Yes, ma'am.
Okay. Miss Barron has given me an email address that's on yahoo.com. Don't give me the address, but is that you?
Yes, ma'am.
Okay. I'm going to pass you in a minute, and Miss Barron may have some questions, and Miss Ladd may have some questions. Okay.
Okay.
Pass the
Thank
witness.
you. Ms. Morgan, I have a few questions. Are you currently married?
No, ma'am.
Have you ever been married?
No.
Thank you. Ms. Rush, anything further from Ms. Morgan?
No, ma'am.
You may call your next witness.
For a limited purpose, we call Trevor Harms. Are you TREV?
Yes, ma'am.
And were you born in 1973?
Yes.
And you know you have been named as the father of Presley, and you've requested a DNA test, correct?
Yes.
And in a little while ago with Miss Ladden and you and I, we discussed that the department will pay for it. It's not a big deal. You just have to go and get your mouth swabbed. You understand that?
Yes, ma'am.
Okay. Are you or any member of your family, not Miss Morgan's family, a registered member of any Native American tribe?
Not that I know of. My biological father's side, there's traces of it, or subjected to, but no, nobody has got a roll card or anything like that.
No one's got a card saying I am a Cherokee Nation member or anything like that, correct?
Right.
And you understand that because Ms. Morgan is a registered member of the Chickasaw Nation, Presley is considered an Indian child according to federal law.
Yes, ma'am.
And because at this point you are an alleged father, you've agreed to the department maintaining temporary managing conservator and you taking the DNA test and not having a contested hearing about this. Is that correct?
Correct.
Do you know, are you in Wichita Falls?
Yes.
Do you know where the Attorney General's office is?
I think,
One more.
yes, I do.
Do you know what Cracker Barrel is?
Yes, I do.
Okay, it's in that direction. You can go at any time, but you're going to need an ID. Do you have a valid ID?
Valid ID? No, it's expired.
They will take that.
Okay.
It's a state issued ID. It's not like a Sam's Club, right?
No.
Okay. Okay. Do you have any questions before I pass you?
Not at this time.
Ms. Barron?
Pass the witness.
No questions.
The department calls Jonah Puller. Mr. Puller, you are the representative of the Chickasaw Nation for this case. Is that correct?
Yes,
And as such, you've reviewed all of the records I've been able to send you. You've talked to the people you could talk to, and you've sent me that declaration I filed today. Is that correct?
that's correct.
And in that declaration, you are agreeing for Presley to remain in care at this time, as well as finding that the department has done active efforts to provide remedial services and rehabilitative programs designed to prevent the breakup of the Indian family, and specifically to try to not do this removal. Is that correct?
That is correct.
And you understand that the child is placed with a licensed foster parent who is not a member of the Chickasaw Nation nor an American Indian.
That is correct.
At this time, however, do you approve the deviation in the ICWA requirements for this foster family to continue to have Presley?
Yes,
Frankly, have I given you everything you have requested prior to this hearing?
yes,
Do you have anything that you need or anything that's required under ICWA that the department has not made available to you?
no,
Pass the witness. The department calls Tim Scantlin. And when you were assigned at that investigation, was Presley an infant residing at United Regional Hospital in Wichita Falls?
She was.
She was not on any tribal land at that time. Is that correct?
That's correct.
The department ended up asking for removal based upon the hospital's request that someone room in with Presley because of some feeding issues. Is that the short version of it?
Yes, ma'am.
And had had United Regional attempted to reach the parents to have them room in?
Yes, ma'am.
Did you attempt to talk to the mother about rooming in?
I did.
Did you explain why she was needed to room in?
I did.
What was her response?
She stated that she was busy moving into the trailer behind her grandmother's home.
Did she also tell you that she didn't understand why she needed to room in to consistently feed Presley?
She did.
Did her actions concern you regarding possible drug use?
Yes.
What did you ask her to do based upon what you saw?
I asked her to complete a drug test prior to a specified time.
And what did she respond to you about that?
She stated that she didn't understand why she needed to do a drug test.
Now, Mr. Harms has told you from the beginning he wanted a DNA test to confirm he is the father, correct?
Yes.
And would you agree with me, placing with someone who isn't sure he's the father is just not an option? Is that fair?
Yes, ma'am.
Okay. You did look at the mother's mother, is that correct?
Yes, ma'am.
Is it your understanding that she has been charged in Jones, the mother's mother has been charged in Jones County, Texas, with possession of a controlled substance, to wit, methamphetamine, 1 to 4 grams?
Yes, ma'am.
Did that preclude you from placing Presley with the maternal grandmother?
Yes, ma'am.
Do you believe that at the time of the removal, there was an imminent danger based upon the fact that she was not able to receive nutrition consistently as required by the hospital?
Yes, ma'am.
And in order to alleviate that imminent danger, were you able to find foster parents who were willing to room in and learn specifically how to feed Presley so that Presley could get the correct nourishment?
Yes, ma'am.
Are you asking the court to continue the department as temporary managing conservator?
I am.
Are you asking the court to find, pursuant to your testimony as well as the testimony and declaration of the Chickasaw Nation, that the department has made active efforts to provide remedial services and rehabilitation programs designed to prevent the breakup of the Indian family, and those efforts were unsuccessful?
Yes, ma'am.
Are you also asking the court to find that there was an imminent danger to the physical health or safety of Presley that required the department to exercise its rights under the Texas law and remove the child?
Yes, ma'am.
Are you asking the court to find that the evidence, including the testimony of the qualified expert witness being Mr. Puller, made by written declaration under penalty of perjury from Oklahoma law, demonstrates that a continued custody by the mother of Presley is likely to result in serious emotional or physical damage to the child?
Yes, ma'am.
Are you asking the court to also order both Mr. Harms and Miss Morgan to submit to a hair and UA drug test?
Yes, ma'am.
And you understand that the mother at least has completed forms to allow the department to do home studies?
Yes, ma'am.
Do you know if the father has?
I do not.
Do you believe that Presley is doing well in her current foster home?
I do.
Have you actually seen any of the feedings?
No, I have not. Not outside of the hospital.
I'm sorry, say that again, please.
Not outside of the hospital.
Did you see it in the hospital?
There was a nurse feeding at one point after we'd arrived.
Is there anything about Ms. Morgan, Mr. Harms, or Presley that this court needs to know before I pass you?
Not to my knowledge.
Pass the witness.
Thank you. Mr. Harms, do you have any questions for Mr. Scantlin?
Yeah, there's
If you will, make sure you ask them in a form of a question, please, sir. And y'all can't speak to each other. This is the so it's only his turn, Mr. Harms' turn to speak.
When was I asked to room with her? We saw her the night before, twice a day.
Wait one moment,
I'm
sir.
sorry.
This is a court hearing, not a conversation. So,
Oh, I'm
Mr.
sorry.
Scantlin, Mr. Harms has asked what day or time did you notify him and request him to room in?
When I had the discussion with both of them, I talked to both of them about doing drug testing so that they could room in. I was specifically addressing Alexis in that conversation, but I was talking to both of them at the same time.
Your next question, Mr. Harms.
You specifically asked me to room in?
I did not directly, no.
I thought you said you just did.
I was talking to both of you whenever I had the conversation. The
Well, then you
hospital
didn't-
had directed everything towards Alexis, and that was the conversation that I had with both of you.
This is being recorded. I can only record one voice at a time. So what is your next question, sir?
Are you talking to me, ma'am?
Yes, yes, sir, Mr. Harms.
Okay. How comes the nurse never asked me to never room in or anything like that?
Objection, speculation, hearsay.
I'm going to sustain that. He does not have to answer that question, sir. You may ask your next question. That is,
Was the day that we lost custody the day that you asked us to? Being out on the farm,
wait, one moment. Wait,
I'm
one
sorry.
moment. The day that you lost custody, was that the date you asked what?
to room in.
Mr. Scantlin?
Yes.
Why was your determination? What was the determination that you deemed the situation or the to be dangerous for Presley? Presley hadn't been released from the hospital yet, and I was moving my stuff away from
Objection, we've gone, objection testifying, not questioning.
So
Rephrase that question, Mr. Harms, please.
the day that he came out there, I was moving my stuff out, and he determined
Objection.
Ms. Rush and Mr. Harms, if y'all will, I want to give Mr. Harms some slack. Mr. Harms, this is not a conversation. I need you to ask Mr. Scantlin a question. And so you will have a chance in a moment, sir, to tell me what you want to tell me. But this is the time where you are asking questions of Mr. Scantlin. So please.
Okay, why whenever after you left, the nurses, we got on the phone with the nurses and they said what you told us was not that at all.
Objection, hearsay,
I'm
and
going to
speculation.
I'm going to sustain that. I know you're not an attorney, Mr. Harms, but he can't answer to anything that that anyone else told you. He can only answer what he was there involved with. Everything else is considered hearsay. So he can't comment on anything that the nurse may have or may not have told you.
Okay.
If that kind of helps you frame your question.
I have one more question, I guess. When we were all talking about Alexis's urine test, you told us that it was high levels, that you couldn't believe it. There were so high levels, and you kept saying that. Well, that's why I'm here. That's why I'm here. It's because of these high levels of marijuana. Was that false or was that true? Did you lie?
Wait, stop right there.
I'm sorry.
It helps if you just do short questions. Mr. Scantlin, can you answer whether or not you recall making those statements? Yes or no?
I made statements to that degree, yes.
Your next question, Mr. Harms.
That's it. I don't have any more, Judge.
Thank you. Ms. Barron?
Thank you, Your Honor. I want to just clarify some of the questions that Mr. Harms was asking regarding the drug test. Was that a urine drug test that my client, Miss Morgan, completed that you were discussing with Mr. Harms?
At the time, yes.
Okay, and that the results of that urine drug test were not included on the affidavit of removal, nor have those results been provided to any of the parties in this case. Isn't that correct?
No, ma'am.
Okay. Now, Miss Morgan did admit to you that she did use marijuana. Yes?
Is that a question?
Yes, she did.
Yes.
And that you don't have any drug testing results indicating that there were any other illegal substances besides the marijuana that she admitted to using. Isn't that true?
Yes.
After your unsuccessful attempts to contact Miss Morgan, did you later find out that she had broken her phone and that it was not in working order?
Can you specify timeframes?
After you had made unsuccessful attempts to get in touch with Miss Morgan, did you find out that her phone was not in working order because it was broken?
I knew prior to that.
So you knew that her phone was broken before you attempted to call the number that you knew was broken?
No, ma'am. I attempted to contact her a few times, and then she contacted me and said that it was broken, told me it was going to be fixed the next day and that I could continue contacting her on it after that. She later then told me she has never gotten it fixed and to call her at her grandmother's number.
I'll pass the witness.
Thank you. Ms. Ladd,
I have no questions.
thank you. Anything further, Ms. Rush?
Yes, sir. Yes, ma'am. Tim, this case was originally called in for a reason other than the rooming in issue, right?
Yes, ma'am.
And isn't it true that Presley tested positive on a meconium for THC and marijuana?
Yes, ma'am.
However, you did not do a removal based upon her positive test and Alexis's positive test, correct?
Correct.
Regarding Mr. Harm's questioning of you, at any point has he said, gee, I'm the dad, let me take the kid, I'll room in with her?
No, ma'am.
In fact, has he consistently said, I'm not sure I'm the dad, I want a DNA test?
Yes, ma'am.
The one person we are absolutely sure is a parent is Miss Morgan, right?
Yes, ma'am.
Says on looking at your affidavit that was filed, it's my understanding that Miss Morgan told the other investigator that she believed Mr. Harm was using meth, or am I mistaken?
I believe so.
And on April the 23rd, is that when you first heard about the rooming in issue?
Yes, ma'am.
And was that from United Regional?
Yes, ma'am.
When we talk about you attempting to contact her, did you attempt to contact Miss Morgan in person?
Yes, ma'am.
And was that at the trailer that is on the property owned by, I believe, Miss Morgan's grandmother?
Yes, ma'am.
And did you go out there because you couldn't get her on the phone?
Yes, ma'am.
Did Miss Morgan's grandmother give you permission to go into the back and look for Miss Morgan?
She did.
Is that when you had the conversation about rooming in?
Yes, ma'am.
Is that also when you asked them to take a drug test?
Yes, ma'am.
So it was in person, right?
Yes, ma'am.
And was that also the time that Miss Morgan told you she was busy moving and didn't understand why she had to room in?
Yes, ma'am.
At any point, did Mr. Harm say, gee, I'll room in? I know you're not really asking me, you're asking Miss Morgan, but I'll do it.
No, ma'am.
Is that the time you asked Miss Morgan and Mr. Harms to take drug tests because of their behavior?
Yes, ma'am.
Is that when Miss Morgan told you, I don't see why I should take a drug test?
Yes, ma'am.
At that point, did you actually talk to her about her grandmother maybe being
Yes,
an
ma'am.
option? What did Miss Morgan tell you about her grandmother?
She stated that her grandmother had Alzheimer's, that she was very sick, and they expected her to pass away at any day.
Did she seem that way when you talked to Wilma?
No, ma'am.
Okay, let me interrupt right here. This is a court hearing. It's very inappropriate to make any facial expressions. And so I'm going to ask Mr. Harms and Ms. Morgan to please refrain from shaking or having any response to any of the testimony that is being provided. Thank you. You may continue, Ms. Rush.
And it was only after you spoke to Ms. Morgan with Mr. Harms present and had been notified by the United Regional that you made the decision to ask for a removal with court orders. Is that correct?
Yes, ma'am.
Pass the witness.
Mr. Harms, do you have any questions for Mr. Scantlin at this time? Pardon me.
No, ma'am.
Thank you. Ms. Barron,
No further questions.
Ms. Ladd,
To your knowledge, do Mr. Harms and Miss Morgan reside together?
Based on the information I'd received, yes.
And to your knowledge, is Mr. Harms on probation?
Yes.
What is he on probation for?
I believe it was a drug charge.
Did you speak with his probation officer?
I did.
And after speaking with the probation officer, did you have concerns of continuing drug use?
Yes, ma'am.
I'll pass the witness.
thank you. You
No
may call
question.
your next, you may call your next witness, Ms. Rush.
Department rests.
Thank you. Mr. Harms, do you have any witnesses you'd like me to consider at this time?
No, ma'am.
Let me ask you a few questions. What I have been told is that at this point in time, you are in agreement with Presley remaining under the umbrella of the department. Why, if you are determined to be the father and Miss Morgan works services, is that correct?
Yes.
And you have indicated that you have requested a genetic test.
Yes, ma'am.
Are you currently married to anyone?
No, ma'am.
Have you ever been married to anyone?
Yes, ma'am.
And when was that marriage? How was that marriage ended? Through divorce?
Yes, it was a divorce. I'm sorry. Yes.
No, that was a poor question on my part. And approximately how long ago was that marriage?
You see, it ended in 2017, I believe it was.
And is there anything else you would like me to know regarding this situation that's not been addressed today?
No, ma'am.
Let me tell you, in the state of Texas, you are not given a court-appointed attorney in a civil case. This is a civil case.
Okay.
You have the right to request a court-appointed attorney, but first of all, you have to be declared to be a parent. And right now, because neither you or Miss Morgan are married to each other, and there was not a acknowledgement of paternity signed, and you've requested a genetic test, you're not considered a parent until that result comes back and it's found that you are the biological father. If at that point in time you are declared to be the biological father through testing, then you have the option to request a court-appointed attorney. It's a two-step process here in Texas. One, you have to be opposed to what the department is asking, and two, you have to meet the financial requirements, and you have to meet both of those. I have absolutely no idea what your financial requirements are. And today you're not a parent legally, and you're telling me you're not opposed to what the department is seeking for today. So if in the future, if you're found to be the father and you want to request a court-appointed attorney and you're no longer in agreement, then you may certainly do that. And you may ask Ms. Columbus for an indigency affidavit, and we can address that at any given time. In addition, you have the legal right to request or to retain your own attorney at any time during this process. And you have the right to do that, and you have the right to represent yourself like you are today. Miss Morgan, because of her Indian heritage, she is required by law to get a court-appointed attorney, and that's why Miss Barron has been appointed to her. So that's a little bit of the differences. I have already signed an order for genetic testing, so you can go to the Attorney General's office, and it's located back behind Cracker Barrel. And you can do that as long as it's during 8 to 5 working hours. And I'm going to order you to do that by May the 19th.
Yes, ma'am.
They'll just take a swab, and it shouldn't take, as long as it's not, it's usually not longer than 30 minutes. But saying that, I may have just jinxed you. And so let me knock on wood, and I apologize. But if you will go and do that, then I'll make sure the child is drawn. Right now, it usually takes anywhere from 4 to 6 weeks to get the results back.
Okay.
So, do you have anything else you would like me to know? I know it's a very unusual situation for you because you're a parent. You may be a parent, you may not be a parent. You've kind of got one foot in this case and one foot out. Do you have any, and there has been a lot of questions thrown at you. If there are, I will try to answer any question you have. There are legal reasons why I may not be able to answer a question. If I can't answer it, I will tell you, and I will direct you to someone who can. Do you have any questions about what you have agreed to do today?
No, ma'am.
Is there anything you would like to tell me that has just popped up and during this rounds of questions that you haven't had a chance to voice?
No, ma'am.
Thank you. Ms. Barron, any witnesses?
No witnesses, Your Honor.
Ms. Ladd, any witnesses?
No, Your Honor.
Does everybody rest and close?
Yes, ma'am.
Yes, Your Honor.
Ms. Ladd, do you have a recommendation as attorney ad litem?
The department to conservator and continue the place.
Thank you. And Mr. Puller, do you have anything you would like to add as this case has progressed through the day?
Not at this time, Your Honor.
Thank you. And Ms. Lyerly, as a guardian ad litem, do you have anything you would like to add?
Just that the department take TMC and he stays in the placement she's in, sorry.
Thank you. And Mr. Foster Parent, is there anything you would like the court to know about Ms. Presley?
She's doing fine. She's up to 4 ounces every 3 hours. She sleeps halfway through the night. She's doing great.
Thank you. Is there anything that you need from Ms. Presley that's not already being provided to you?
We can always use diapers. She has everything.
Great. Thank you, sir. Is there anything else that needs to be addressed at this time?
No, ma'am, just the findings.
At this time, the court is going to approve and find that all of the prerequisites for an exigent removal were met by the department. The court is going to find by clear and convincing evidence that there was a danger to the physical health or safety of the child, which was caused by an act or a failure to act of the people entitled to possession. The court further finds it is contrary to the welfare of the child to remain in the home of a parent, and the urgent need for protection required the immediate removal of the child and reasonable efforts consistent with the circumstances, providing for the safety of the child, were made to eliminate or prevent the removal of the child, and reasonable efforts have been made to enable the child to return home to a parent, but as of this time, there's still a substantial risk of a continuing danger if the child is returned home to a parent. The court is going to also make the finding that the court does find that Presley Morgan is an Indian child within the meaning of the Indian Child Welfare Act. The court further finds that the department has properly served the notice of pending custody proceeding involving the Indian child by registered mail in conformance with ICWA, and has specifically notified the tribe, and the tribe is participating in this hearing. In addition, the court further finds that the tribe has not petitioned to intervene at this time, and a petition to intervene by the tribe has not been granted. The court does find that the child is not a resident of the reservation, and a petition to transfer the proceedings to the tribal court has not been filed. And so consequently, this court still has jurisdiction over these proceedings under 25 USC 1912. In addition, the court does find, in having examined and reviewed the evidence, including the sworn affidavit from Mr. Puller, and based upon the testimony today, that the Department of Family and Protective Services has made active efforts to provide remedial services and rehabilitation service programs designed to prevent the breakup of the Indian family, and that those efforts have proved unsuccessful. And there is clear and convincing evidence, including testimony of a qualified expert witness, that the continued custody by an Indian parent is likely to result in serious emotional or physical damage to the child at this time. And based upon the information and testimony provided today, the court does find that, having examined and reviewed the evidence, the court finds there is good cause to deviate from the statutory placement preferences pursuant to the Indian Child Welfare Act, and the tribal representative has agreed to that deviation at this time. The court is going to order and name the department as the temporary managing conservator of the child. The court will name Miss Morgan as a temporary possessory conservator of the child. The court is going to defer any findings regarding possessory conservatorship regarding Mr. Harms until his paternity testing is complete. The court is going to approve the agreement of the parties and order that the parents undergo parenting, counseling, and that can be both individual and family, a substance abuse assessment, and follow all recommendations, random drug screens. All drug screens involving the parents will be a regular drug screen. It can be a hair follicle, alcohol testing, and a RAUA, RA oral. In addition, all testing will include an expanded opiate panel as well as fentanyl testing. Both parents are ordered to undergo, and these orders for you, Mr. Harms, is only if you're actually identified and determined legally to be the father. to undergo a psychological evaluation if recommended and follow all recommendations, obtain and maintain employment or a legal source of income, obtain and maintain safe and stable housing, for each parent to develop and their family service plan and to comply with that family service plan. Keep all, and this, Mr. Harms, you are under a court order to do this, the following. You are to keep all parties updated with your contact information, email information, relationship, and employment status. Allow the department, CASA, the tribe, as well as Ms. Ladd to make announced and unannounced home visits, to provide in-kind child support, such as diapers, and to attend case meetings, attend court hearings involving Presley. You're both to sign medical, mental health, and record and drug releases, and to provide an email address, which I understand both of you have done. You're court ordered to open your email from eFile Texas within 3 days. You can open it and save it, but if you don't open it within a certain time frame, the information will disappear and you can't obtain it. That will be your notice, and you will get a copy of everything that is filed in the court. And Mr. Harms, until you are determined to be a father, then that is your responsibility to do that. In addition, the court does find that Presley was not removed for any of the Texas Family Code 262.116 factors. Presley was not removed based on the fact that she may have been homeschooled, may have been from a disadvantaged background, may have received medical marijuana, may have been behind on immunizations, or engaged in independent activities, nor is the removal based on the fact that a parent received a nonviolent misdemeanor charge, or a parent sought out a second medical opinion, or that the parent and child tested positive for marijuana alone in a manner which significantly impaired the physical or emotional well-being of the child. The next time that we are in, the court is also going to add the following provision. The court is also going to add and order both of the parents to work closely with the tribe, and a representative of the tribe, it may be Mr. Puller, it may be someone else, will may reach out, and you are court ordered to respond to any of the contacts from the tribe, and to follow any of the requests if the tribe has any throughout the course of this case. In addition, the court is going to order both of the parents to undergo a hair follicle and a UA. The court is going to order both of the parents, this is for you as well, Mr. Harms, to undergo a hair follicle and an expanded, and a UA, both of them to include an expanded opiate panel and fentanyl, and that is to be completed before 3 o'clock tomorrow. And if you will wait after this meeting is over, Ms. Columbus can tell you where to go. And as Ms. Rush explained earlier, this court's ruling is that you must undergo the drug screens. Visitation is not going to be based upon what the results of the drug screens are. Visitation will be based on whether or not you go for the drug screens. What I'm looking to get is whether or not there is a baseline for any issues, and what issue, if there are issues, or if there's not any issues. The only way that a family service plan that is narrowly tailored to meet your requirements can only be developed if we actually know what issues we're looking at. In addition, the court is going to tell both of you each time I see you, this is not a threat. I'm required by law to tell you that if you're unable to provide Presley with a safe and stable home environment, your parental rights to her could be restricted or terminated. The next time that we are in a courtroom setting is for a status hearing, which is set for June the 16th of 2023 at 9:30. The initial permanency hearing is set for October the 20th of 2023 at 9:30. And the second permanency is set for February the 16th of 2024 at 9:30. And I will let the parents know, statutorily, I'm required to have those hearings within those time frames. I set them out so far so that you can work around any work schedule or any services or anything like that you need. And those dates will be included in the temporary order that will be filed. And it's usually in the middle, right above my signature. So you should be getting a copy of that so you can make arrangements for any of that. And I am going to order you, Mr. Harms, to provide the department with any names of possible family members that you would like to be considered as placement if you are indeed to be found a father. And I'm going to order you to have that done by May the 19th as well. The court is going to waive the appearance of Ms. Presley today and find that the foster parent as well as Ms. Ladd have adequately represented her interests.